Oh, I'll give it to her. Yeah, okay.
That's right.
So maybe,
Yeah.
Here, you can take mine, just, she's saving that for some.
Oh, there's one back here.
No, sit down.
Oh, perfect. I didn't know if you wanted those there, and I have a couple in my office as well. The COA was very grateful to, through the Mass Bar Association, to be one of the communities that was picked to have a elder law education presentation that would be made available to us. And the attorney that was, I don't know if
Matched
signed
up, or,
is
yeah.
matched up for the Stowe community is Erin McBee, attorney at law. And so she is going to be doing a discussion, taking control of your future, a legal checkup. She's very open to questions and answers, wants this to be a very lively, engaging presentation so that you're very clear when you leave this room about anything that you might have a question with. So we're very happy and fortunate to have Erin here. And thank you very much. Enjoy the presentation and welcome.
Yeah, thank you for having me. Happy to spread the word and share the knowledge here.
Great.
Answer questions you may have as we go along. So hello everybody, my name's Erin McBee. I have my own law office in the town of Harvard, just down the road a bit from here. I've been there, gosh, I guess it's been about 10 years. Before that, I was in North Andover, and before that, I was in Texas, Somerville, Texas. So I'm licensed in Texas too, if you have any Texas questions, but I don't anticipate that we will, although I do run into it every once in a while, which is kind of surprising. But my mainstay is Massachusetts. So I was going to do a brief introduction, but I didn't know if anybody had any, I don't know if you have familiarity with some of the estate planning concepts like wills, and probably do, powers of attorney and healthcare powers of attorney. Imagine the COA has probably been on you for healthcare powers of attorney in some way, shape, or form. They're usually pretty good about that. Did anybody have any specific questions or topics they wanted to make sure are covered today? Yes?
trusts.
Trusts.
Same.
Yeah. Great. Anybody? Any other? Yes.
Well, there is a trust and how you pass on your assets after you conquer, so to say.
Okay. Or if you disappear.
Yeah, right.
Okay, great. Anything else?
Avoiding probate.
Avoiding
That might be
probate.
the trust, too.
Yeah. Okay. So I'll go ahead and get started because it's 7 after. Did you have another? No question. Okay. So in general, I'll just do a brief summary of estate planning. Estate planning consists of planning for what happens to your assets after you, as you said, it conk off, or however you want to phrase it. And also what happens to your property and the handling of your affairs if you're incapacitated during your lifetime. So wills and trusts are what would cover the disposition or distribution of your assets after you pass away. And powers of attorney handle everything while you're still here, as well as trusts somewhat as well. So if you were to become incapacitated, it's nice to have a power of attorney and a healthcare power of attorney in place already, because without those, you have to go to court. A loved one would have to go to court or a healthcare facility to have somebody appointed to take care of those decisions for you, which is not really what most people would like to have happen. You want to have some control ahead of time on who those people would be that would be handling those affairs, which is why you have those documents drawn up. And then wills and trusts are handling where everything goes after you pass away. Trusts are a little complicated. Actually, they're a lot complicated because if you fund them during your lifetime, they can also have the person who's the trustee can take care of those assets during your lifetime if you become incapacitated. And there are also many different kinds of trusts out there, which leads to a lot more confusion. So just briefly on the powers of attorney, there's the durable power of attorney, which is appointing somebody to handle all of your financial affairs, your mail, taking care of your pets, all of those major decisions, handling investments. That's the durable power of attorney. And the healthcare power of attorney is your healthcare decisions. So with the healthcare power of attorney, it's also good to have a living will or advance directive, as well as a MOLST. And I'll just go a little bit onto that because that gets confusing as well. The MOLST form, I don't know if they've had a presentation on the MOLST form here yet.
What was it, a
So-
mulch?
Yeah, it sounds like mulch. MOLST, Massachusetts Orders on Life-Sustaining Treatment.
Oh, mulch.
MOLST, yeah, very weird acronym.
Yeah.
So not very memorable. So that is a form that you fill out with a healthcare provider. So if you're ever admitted for surgery or an emergency, they'll generally have that filled in again at that point in time. And either you fill it in with that healthcare provider or your healthcare agent would fill that in for you if you cannot. So that contains your end-of-life care health practices that you would like or would not like intubation, all those wonderful things to think about, and the preferences that you would have at that point in time, and CPR or resuscitation would be covered in that form. The living will, which is also called an advance directive, is similar, but that's something that you would prepare well ahead of time just to give your healthcare agent some guidance on how to fill out that MOLST form if and when they have to. It's really hard to fill out a living will for every scenario. They tend to be very general because as your health changes, you might have situations where maybe you're 105 years old with stage 4 lung cancer. Your decisions will be different than when you're 80, and still playing golf. So that is why the MOLST is filled out as needed if you ever need treatment.
Once you fill out that form, which I have filled out at the hospital, how
Yeah.
long is it good for, or do they,
It doesn't have an expiration date.
doesn't, okay.
Yeah, so sometimes if you don't have an agent with you or they don't have time to fill out another one, a lot of times they tell you to put those types of forms on your fridge, have it on a magnet, and then they take paramedics will have it, take it to the hospital. Unfortunately, there's not a database that has all these documents on it. Different healthcare providers like, Steward Healthcare, they might have their own database that they share with their facilities. So if you go to any Steward place, they might have your MOLST and your living will and your healthcare that you've shared with them on their system. They may not. Another tricky thing is,
Excuse me.
yes,
Could you summarize what is the advantage? Why would you want to have this mulch?
the MOLST form? Yeah. So if you have really strong wishes about types of end-of-life care treatment you would like and wouldn't like, you would want to have this. Plus the facility, the doctor or healthcare provider is going to want to have this on hand so they can instruct the nurses and the other staff on what kind of care. In case the beeps start going off a lot in your room, they'll know, okay, we can do CPR. There won't be no question about whether or not they should implement those procedures. And it also just gets you thinking about these decisions and hopefully being able to get to a point where you can share your decisions and desires with your loved ones as well. Now, the healthcare power of attorney, you may have filled one out and then you might go somewhere and they'll have you fill another one out. That's fine. My preference is you have one that you have drafted, and obviously my ideal is that you always have it with you and you can always give it to whomever you want. That's kind of impossible. If you do fill out another one, it tends to negate the first one, so just try to be consistent on your healthcare agent wishes. But it's a common thing when you get admitted to a hospital and you might forget that you already have one, you fill out another one just to make sure there's somebody, that's appointed. Yes?
Is that the same as the healthcare proxy?
It is. The healthcare power of
So
attorney,
it's the
healthcare
same
proxy
thing
are
as just-
interchangeable. There are subscriptions you can get in different software programs where you can upload these documents and then carry a card, and then they can always see what these documents are by logging into that website that's on the card, which is kind of nice too. And they do have a chapter on healthcare powers of attorney in here too, so if I went too fast, which I was trying to talk more slowly, but I am a fast talker, it should be in here as well for you to reference later if you had any further questions on that. So I wanted to talk about those powers of attorney at the beginning because they're the easier concepts to grasp than the trust and the other things. So before I go on, I don't know if anybody had questions on durable powers of attorney or healthcare documents. Okay. So we'll go on to wills and trust. I'm going to start with the will because that's the easiest one to talk about. I think everybody knows what a will is. It is when you appoint somebody to be in charge of your estate after you pass. They're called the executor or a personal representative now. and then you just list where you would like to have all of your possessions go. You can have things divided by real property, tangible property, which are things you can touch, like paintings or dishes or jewelry, and then what they call the residuary or the residue. It's typically how you'll see it in a will. You could have everything, if you want everything to go to the same person, it could just all go without having to have separate sections. As far as the tangible property, it's kind of tricky because it tends to be the lowest value property that you tend to have, but it's usually the thing that's fought over the most. So it's good to try to come up with a list if you have certain possessions that you know people really want, or that you really want to go to certain people, to draw up some kind of memo that says, maybe with pictures, this is where I want this to go or that to go. And your will can reference that memo, and it is considered legally binding if your will says, I may have drawn up a memo, and you would keep that with your will, and you can change it whenever.
I have a question. If I were to die in the state of Massachusetts, is my Florida will good?
Yes. If you executed it per the requisite requirements in Florida, which I'm sure you did with the number of witnesses you needed, and you were over 18 at the time that you drafted it, then yes. Yeah.
I had a will made up some time ago before my daughter was married, and she lived somewhere else, and my son lives somewhere else. So it has their old addresses, and her original marriage, my daughter has her original marriage, her pre-marriage name.
Okay, her maiden name, yeah.
Yeah, maiden name, thank
Yeah,
you.
you're welcome.
So, does anything have to be done about that? Because the names change,
Yeah,
the addresses?
that happens all the time, and it's a common occurrence. So at the time when you pass away through the probate process, your daughter can sign an affidavit stating that I am the same person as myself with my maiden name if that's necessary. But that's something the courts are used to. Ideally, you could redo your will and change that all up. But, I mean, the courts understand people move all of the time. Even after probate is open, that happens a lot too. So not having the correct address is fine. As long as everybody knows, you know, that everybody is notified of your passing and you haven't completely lost touch with them, it shouldn't be an issue. So otherwise it can get tricky.
Well, you mentioned probate. I mean, with a will, he still has to go to probate, or how does that?
Yeah, that's a good transition. So the will is only going to handle property that's in your name alone when you pass, and that doesn't have a beneficiary designation. So in those cases, that property would go through probate whether you have a will or not. If you have a will, the will will say, this is the personal representative who will handle everything, and it would tell the court where you want everything to go. If your property, let's say that you have a joint bank account with your daughter, and your house you have maybe jointly held with another person, and all your other property has beneficiary designations, there'd be no need to go to probate. Or if you had put everything into the name of a trust, there would be no property that the probate court would have to oversee. So the probate process, it's put in place to make sure that that property wasn't just taken after somebody died. You want to make sure it goes to the right person. It's also a mechanism for creditors to get paid back for debts that were incurred by decedents. So a lot of it is kind of driven by that. So if there were, certain creditors, they might be able to open probate even if you put everything in a trust, because you can't just go and say, oh, I know I don't have much time left, I'm going to max out all my credit cards and not have any consequences. They're always there. They might have a harder time getting into that trust, but, they'll come looking. And that's the same with Mass Health. Mass Health is a creditor. If you had needed Mass Health long-term care benefits, they would be one of those creditors too. But,
So
go ahead.
you're saying that even if you have a trust, you still need to go through probate?
It's a good question. Sometimes you do. This is what I see happen. You might have, when you pass away, those creditors I mentioned include the IRS, and the last year you were here, you have to still file taxes. Somebody has to file taxes, income taxes for that year for Massachusetts and on the federal level. And you might end up with a tax refund, and that tax refund will be made out to the estate of yourself. And you can't cash that check unless you have an estate account. And you can't set up an estate account unless you have something from the probate court that says you're the person in charge who can set up the estate account. So it is often hard to completely avoid probate. because of those instances. Sometimes I've had cases where the tax refund or some unexpected refund from, like an assisted living center of a small amount would come to an estate where there's a trust already in place. And the bank would say, okay, you only have a small check that's coming in. We're not going to make you open probate. Sign an affidavit that you're representing this trust estate and that, there's no other heirs. Sometimes they would let the attorney deposit those checks for the trust. But that's not that often that you see that. So it is very hard to completely avoid probate, I guess, is the answer. So, but your family could decide it's not worth going through having to get a probate open just for this small check, and then it would go to unclaimed property. And that would be what would happen with it. One asset that's really frustrating to deal with is cars, because you can't really title them. You could put them in the name of a trust, but often your car insurance provider will charge a higher premium. That's not always the case, but that's often the case. And so often it's easier just to leave it in your name to save on those car insurance premiums. But cars are usually the one thing that might make you have to open a probate process. If the only property you have upon your death that has to go through probate is less than $25,000, then you can do something called voluntary administration, which is much less onerous than probate. It costs less to open. It's $115 filing fee instead of $300 or $400 for probate, because you're only dealing with a small amount of money. So,
And what was the name of that again?
Voluntary
Voluntary
Administration. Yeah. Did they cover? I don't remember seeing a probate chapter in the book. But yeah, voluntary administration. So ideally, if you had a small refund check, or there isn't there? Or something of that matter, you would do voluntary administration. You still, no matter which of these, voluntary administration or a probate process, you still have to give notice to the people that you. Oh, the voluntary? Did you have a question about voluntary? Or yeah.
Well, yeah, that's the same as probation.
It's very similar, but it's different because you're only really taking care of a small amount of property. You're not, if you have real estate, you're not going to be able to handle that through a voluntary. You're going to have to do a formal or informal probate. But it's there because there's a lot of instances where there's a $5,000 check from the IRS and they don't want to make people go through too much trouble. But the problem is that whenever you go through a probate proceeding, you have to make sure that all the people who should receive notice. And those people are considered interested persons, and they are your beneficiaries that you named in your will if you had a will, as well as your natural heirs at law, which would generally be your spouse and your children. So those people would have to receive notice, and then they could appear or not appear if they oppose the appointment of the person or the disposition of the assets too. So, yeah, I know. It's somewhat easier than it used to be. They've tried to make this whole process with probate and voluntary administration simpler. There was a new probate code that was adopted a few years ago. So it is better than it used to be. And for me, because I do it more often than most other people do, it isn't so bad. But when you look at all the paperwork you have to fill out as somebody who's not doing that type of paperwork all the time, it is a little overwhelming. But a lot of them are duplicative entries, and it's not too bad. So. But if you have the will, it makes that whole process a lot easier, because what if you did find some property that you forgot that you had? Or maybe the person had a wealthy aunt somewhere and they ended up inheriting money and it went into their estate. It's always nice to have a will that names somebody to be the personal representative. That makes things a lot easier going forward. Yeah. And a lot of times you could have terms in that will that say there's no necessity to have a probate bond. That makes it less costly to do probate and makes the whole process a lot easier. And terms like that make it easier. So it's always good to have a will anyway, just like even if you have a trust and all your assets are in that trust, so when you become incapacitated, if you do, not when, if you ever become incapacitated, your trustee can handle those finances for you, you still want to have a durable power of attorney because there's still some things that the trustee doesn't necessarily have control over, like your mail or minor things like that you didn't even think of. So it's always good to have that, or if there's some asset you forgot to put into the name of the trust, you have the power of attorney agent who could handle that for you.
Can the trust,
Oh,
With regard to the wills,
Yeah.
If a number of siblings are children are listed
mhm.
in the will,
Okay.
and one of the siblings has passed,
Mm-hmm.
do their children get into the picture, or?
Yeah, and I forgot I should repeat the questions for the camera. So the question is, if you have a will and it names, let's say, 7 children, and 1 or 2 of these children have passed, leaving descendants, then the will, generally people will draft it so that it says that if per stirpes is the general term you'll see, which means that if a child has died or a beneficiary listed has died, it goes to their descendants. And then even without the will, if you didn't have a will, and you had 7 children and some of them had passed, their children are interested parties now, so they would receive notice as well.
They automatically participate.
Yeah, unless you had a will that said only my living children will inherit from me, and then in that case only the children who outlive you would be the.
So the per stirpes clause that you
Yeah.
mentioned would have to be indicated, and for the children of the siblings to be participating.
Well, if you just listed all of their names and one of the children had died, you'd have to look at the rest of the terms of the trust in the definition section to see if something addresses that. Because there might be some other language in there that says if one of my descendants had passed, then their descendants would inherit. Even if it doesn't say per stirpes, you want to look at that whole document. But generally people would put in, if one of them should predecease me, then their descendants, or they do the, yeah.
I see. Thank
Yeah,
you.
you're welcome. Oh, he had a question really quick.
it's the power of attorney
Mm-hmm.
trust. The trustee of the estate, can he be assigned power of attorney?
Oh, I
Or
see.
is it just somebody else?
Oh, good
who does
question.
that? Yeah.
So he's asking about the power of attorney and the trustee. So the power of attorney, you can have the person named as your power of attorney agent can be the same person who's the trustee under your trust. They don't have to be different people. So it can be the same person. Is that, okay. Any kind of, oh, she had a question.
Yeah.
Really quick.
If then, say you have in your will, everything is, and you have several children,
Mm-hmm.
everything is going to be divided equally.
Mm-hmm.
One of those children dies, but she has no descendants. What happens to that?
Then if you had a will that's distributed everything to your children and one child died leaving no descendants, their share will go back up into the will and get passed down amongst those others. I have had clients who had multiple children, some of whom predeceased children. It was tricky. So I had a woman who had 5 kids. Some had 5 kids of their own. One had 1 had 3. And we didn't do per stirpes because it didn't seem fair to the grandkids that one grandkid who was the only child was going to make out so much better than the other grandkids. So we worded that differently to make that more fair. But you can do it any way you want. So you had a question as well?
Yeah, I just want to understand what is the benefits of having a trust and how do you set it up?
Sure. Okay. So are there any more questions on the will? We can always go back to it. So the trust, most people, when you think of a trust, it's usually the revocable living trust, which means you can revoke it at any time during your life. You can change it. You're in control. You're the initial trustee. And then when you pass, it becomes irrevocable. It can't be changed, which is what you want because you want those terms to be honored after you pass. So to set that up, you would have the document drafted. And the critical piece is making sure that you actually put assets into the name of the trust. Or at least have a will that says everything I have pours into the trust upon my death, which makes probate a lot easier, because then you're just taking everything and putting it into the trust, and that's the end of it. That way also, in case you didn't get everything into the trust, it's clear you want it all to go into the trust. But even if you don't put assets in the name of the trust during your life, if you have that will that pours in there, it's still going to go per those terms. Or if you don't have the will, then the trust doesn't have anything in it and it's not honored.
But if you have a will, what does a trust, why a trust?
Yeah, that's a good question. Why have the trust and the will? You don't always need to have both. It's kind of like the fancier estate planning option. It's really important if you have a descendant or somebody you want to leave money to who's disabled, then it's good to have one of the trust, or at least have your will name a special needs trust or something of that nature. Or if you had beneficiaries that you weren't too sure of how they would handle their inheritance, like especially young kids, you may want to have them not receive their inheritance till they're older.
But does it protect your assets, the trust, in any way?
That's a good question. So the trust, the revocable living trust doesn't really offer much protection for your assets. To a small extent it does, because people might think, oh, it's going to be too hard to sue a trust. The irrevocable trust, a form of an irrevocable trust, would be one that would protect your assets, because you're giving up control over those assets in that type of trust, and you can't change it. So that is an asset protection vehicle.
Could you explain how that works?
How the irrevocable
The difference
trust?
between the two?
Yeah. So the revocable trust is just like handling the property like it's yours when you're living, but it could have all these terms and directions on what happens to your property after you pass away. So it can maintain some control for those young beneficiaries or irresponsible beneficiaries through that. It can also, for married couples, it could help with some estate tax planning, which I'll get into later because that's really complicated. The irrevocable trust also helps with estate tax savings as well. And you don't have the access to the property in there that you put into the irrevocable trust, but it does protect that asset from creditors. So most of the time, you would see a life estate policy going into an irrevocable trust, or maybe real estate. Or if you had a lot of money and you knew you could get by with a lesser amount, you might put the excess into that irrevocable trust and maybe retain the right to the income that's earned during your life, and then upon your death, have it pass per those terms. So it's kind of a brief explanation. It's kind of confusing because it's still your property, but it's not really your property anymore.
Property into an irrevocable trust.
Yeah.
You can't sell it, or
No, you don't have the right. It could be sold. It could be reinvested if you put those terms in there, but you are no longer the decision-making authority. You see irrevocable trusts that might have the trustee as the person who put the money at the grantor, the same person, and then that doesn't protect you because you have control over it. If you have control, creditors can reach it. So that's why with the revocable living trust, if you had an irresponsible beneficiary, maybe somebody who had a gambling addiction or substance abuse problem or something of that nature, you would want to have their share stay in the trust and maybe only give them small amounts at certain increments or at the discretion of the trustee. Then those funds aren't reachable by a creditor because it's irrevocable and they don't have control over it. So that's one of the advantages of that revocable living trust, is being able to do that.
What would the advantage of putting your home in a trust, a revocable trust?
Yeah, so putting your home into the revocable trust makes it a lot easier for sale after you pass away or transfer to one of your children. Maybe one of your children want to buy the property from the other, heirs at law. It just makes it a lot easier at that point. You don't have to go get a license to sell from the court. It makes things a lot easier.
Would it impact any taxes at all?
It won't, because on the senior, do you get a senior tax discount here? No? Oh well. So sometimes some towns, and not many unfortunately in Massachusetts, give you a senior tax discount. You should still be fine with a revocable trust. But are you talking about like income tax and estate taxes? Yeah. That's a good question, because one of the caveats to the irrevocable trust I was going to give was tax issues. So if you take an asset and put it into your revocable trust during your life, it's still your Social Security number that any income is being reported on, so it doesn't have a tax consequence. But for estate taxes, I'll get to that in a minute. But for estate taxes for a couple, it might have some consequences depending on the terms. There's no tax consequence of putting your home or other property into a revocable living trust during your lifetime. If you were to put it into an irrevocable trust, because you no longer control that, it's considered a gift, and it has a different tax ID number, and that irrevocable trust has to report any income earned and has to file taxes if it earns a certain amount a year. And when you gift property, it has a different basis for capital gains than if you give it to somebody through your will if they were to inherit it. So if you inherit property, your basis is the basis on the date of the death of the person you inherited it from. So when you turn around and sell that property, maybe within that year after that death, it probably hasn't changed in value very much, and there'll be no capital gains issue. If instead the house, let's say it's a house, was put into an irrevocable trust, and then after 20 years after the person has passed, it goes on to the next generation, and they go to sell, their basis is the basis of the person who put the property in the trust, which is you, and your basis is probably a lot less than it's worth at the date of your death, hopefully. And in that case, there would be capital gains they would have to pay on that asset. And capital gains taxes right now are 15 to 20%. The estate tax in Massachusetts, it averages about 5, 6, could go up to 16% if you have, $4 to $5 million. So when you're thinking about estate tax savings, you got to be really careful and mindful of capital gains tax issues with stocks as well, because you don't want to end up paying more taxes after the end of the day. So I don't know if that answered your question about taxes.
I think so.
Okay. And there's another question, yeah?
Do the trusts have to have their own bank account?
Yeah, the trusts don't have to have their own bank account, but when you set up a revocable, you're talking about a revocable living trust,
Right.
you want to make sure it has, ideally, you want to take your assets and put them into the name of this new trust so there's no probate, hopefully. And so if you have a bank account, you would retitle it into the name of that trust.
So you would have to open up a different bank account for your bank in the name of that trust.
Yeah.
What about automatic deposits and withdrawals that are,
Yeah, I know it's so easy for me to say, oh, just put it all in there. But you go to the bank and they might say, no, you need to set up another bank account and you got to fill out these 45 forms. You know what I mean? It seems like how it goes. Some banks might have a process where you don't have to do that, but a lot of times they don't have a choice and you do have to end up filling in the same forms. And yes, if you have auto deposit and they're giving you a different account number, with bank accounts it is kind of a pain because you have to get a new checking, you might have to redo your auto pay. Unless the bank is able to just keep the same account number and retitle it for you, they might be able to do that. It depends on the institution. The other ways to fund a trust is if you have a brokerage account, then you would do the same thing. And yeah, it sounds easy, but it is not. I'm trying to help somebody right now with Fidelity, and oh my gosh. The easiest thing is if you consolidate all your accounts into one institution and then you fund your trust, you're going to have a much easier time. But another way you can do it is changing the beneficiary designations for any property that has a beneficiary, like your life insurance or your retirement accounts. You can list the beneficiary, you can list your trust as that beneficiary without having to retitle it. And the big caveat is your retirement accounts, you do not retitle into the name of your trust because that's considered a distribution. You would only change the beneficiary instead. So if you tried to retitle a retirement account, that messes all your planning up, so don't do that.
So what if you die before you get a chance to do
To
all
finish,
this?
yeah, because it's going to take you 5 years to get this done. No, not really. You can always have an attorney do it. Ideally, if you consolidate your accounts and you have a financial advisor, they will usually help you with that. I mean, of course, law offices are happy to fund the trust for you because it is a slog, but then you're paying the lawyer to fill out all the forms. And if you have a financial advisor, they're getting paid commission usually, and they're more than happy to help you out. Well, maybe they're not more than happy. Maybe they're watching this right now and going, no. But anyway, no, they're usually very helpful filling those out.
What is the difference between a financial advisor and a financial planner?
Oh, a financial advisor, financial planner. Yeah, there are different types. There's fee-based financial and there's commission-based financial advisors. There's different certifications. I'm not so well versed on those. But a financial planner would be somebody who looks at your budget and your future needs and tries to figure out, okay, this is what you have going for this long, and if this thing happens, then this. And a financial advisor is generally just looking at investments, but sometimes they do a mix of both. Generally they do. And then there's fee-based people, and there's commission-based people. Sometimes they're mixed up, and it gets confusing. The fee-based people tend to charge an hourly fee. and then they're more of a fiduciary role for you, but you will pay more. And then there's the commission-based ones who are making commissions on the life insurance or annuities or whatever it is that you're working on with them. But again, if you have one of these, a lot of the banks now have these, so if you're struggling with how to consolidate your accounts and you're comfortable and you like your bank, you could approach them and say, I really want to try to get this all in order to make it easier on my heirs or myself in managing all these assets. So it's good to make a list of everything you have because we tend to forget. I mean, I have a Navy Federal Credit Union account my mom set up for me when I was 1. It's got $114 in it, and my mom won't let me close it. It's one of those things that you know it's going to get lost somewhere, and it's going to be paid. But ideally, you want to try to take care of all those things and get them all as much as you can. Yes?
You mentioned about putting IRA funds into a trust.
Oh, no. Do not retitle any of your retirement accounts, but change the beneficiary to the trust if that's what you desire. Or if you have a spouse, put your spouse first because they can roll it over. I'm so glad you asked this question. Your spouse can roll over retirement benefits. Other beneficiaries can't. So you would want to have your spouse as the primary and then whomever else, whether it's the trust or the children directly. So if you had, like the example I gave of a child that doesn't handle money well, you might want their share of a retirement account to go through the trust. Or if everybody's fine, just list their names individually as a secondary beneficiary, and that's fine too. I don't know if that was going to be your question, but I wanted to get that in there.
No, if you put fund that trust or put all your IRA funds into the trust, is this subject to estate tax then?
Oh, estate tax, yeah.
It reaches a certain limit.
So estate taxes are a doozy. So let me finish on the other questions you might have, and then we'll go there because everybody's going to just glaze over as soon as I start. But that's a good question because it is included. Yeah. Did you guys have more questions on the funding the trust and beneficiary designations? I guess my big message for today is check your beneficiary designations because what if you got divorced 30 years ago, your ex-spouse is still on there? It's going to that ex-spouse. Make sure you've updated those beneficiaries. They trump your will and I don't know if I can use that word, they override your will and they override your trust. So, what was your question?
What is a grantor trust?
A grantor trust. Grantor trust can be an irrevocable trust. It can be a revocable trust. It could be any form of trust. And what that is when the person who puts the money in is going to be the person responsible, generally speaking. Gosh, it's got more than one definition. So a grantor is the person who puts the money into the trust. A grantor trust, that term is an IRS term to determine who's going to be paying taxes on any of the income earned in that trust.
So then the opposite of grantor would be grantee.
Yes, the grantee is the person who receives the property. Yes, like donor, donee. Yeah. But there's no beneficior. It's just beneficiary. And the other thing I just want to highlight too is property that's jointly held. You might have set up a bank account with one of your children or a parent. It automatically, unless it's titled for convenience purposes only, it's automatically going to pass to that joint account holder. So just be mindful of that. Generally, I see this a lot because it tends to be a lot easier to have somebody that you want to have in charge of your affairs on your checking account to make sure that there's no question they have the authority to write those checks. And you generally have your Social Security going in there to cover those costs. It can make things a lot easier. You don't usually keep as much money in that type of account, so it's usually not a big issue as well. But just be mindful of that. If you had, a large account and you put somebody joint on there, it's not going to go per the terms of your will or your trust. It's going to go to that joint owner. So, yes.
Does your personal representative have any control over the
joint account? No. If there's some dispute amongst the heirs about that joint account and the intent when it was opened, then you're talking a lot of hourly attorney's fees. But then there might be some potential that could come back into your probate estate. Or if you'd set it up and it says for convenience purposes only, it may not automatically devolve. But it depends on the financial institution. Talk to them and see how they they do their bank accounts. And there's also transfer on death accounts. That's another way of having an account just automatically passed to another person. I'm trying to think, there was one other. Oh, property, real estate. You might have property with your spouse, tenancy by the entirety or joint rights of survivorship. Your stock could be titled that way as well. And that means that automatically goes to that joint owner instead of through your will or your trust. That's another title issue. Any other questions about assets and titles? And okay, I'm going to go to the estate tax. I think that we got these other, and then we'll talk about mass health too, because that's fun. Okay, so we talked a little bit about capital gains taxes, and then there's the estate tax. So Massachusetts, if you have assets upon your death that total more than $1 million, including any gifts you made over your lifetime over the annual exclusion in a given year, then you're going to have to file an estate tax return, and that estate tax will be around maximum, I think it was 16%, but usually for most people it can be 4 to 6%. So even if you have $1,000,001, they're going to tax back to the first penny. It's not just a tax on the amount over the $1 million. And the annual exclusion gift, they change the amount usually every year or every few years. That's set by the federal government. This year, the annual exclusion amount is $15,000. So that means that you are allowed to make a gift of up to $15,000 to as many different grantees as you wish without there being a gift tax consequence. If you were to give, or an estate tax consequence. So if you were to give more than that $15,000 in a given year to somebody, you're supposed to do a gift tax reporting, filing, and then at the end of your life, or over your lifetime, if you gift more than a large sum, there will be an estate or gift tax levied at that point.
So it's 15,000 to
per
person.
Per person that you give it to. So each grantor can give away $15,000 to separate grantees every year. So if you have a couple, they're each two different. One is the grantor and another one's their own grantor, and that's one way to divvy up assets for the next generation and save them from the estate tax. That doesn't give you a lot of money to take out of your estate, but at least it's a little bit that helps save on estate taxes.
So it's 15,000 per person, as we say.
Yes.
But is there a total limit on the?
I don't.
What if you have 10? So
I don't think that there's a total limit. My understanding it was per grantee, per grantor. Yeah, I don't know if anybody's tested that because it would take a lot of people to get it to an amount that I haven't seen a limit. That's an interesting question. Yeah. Yes.
Who keeps track of this?
Santa Claus. That's always my answer.
Trust
Because as the computer systems improve at the IRS, this might change. But for now, you're supposed to file this gift tax reporting notice to the IRS, and they have your name somewhere, and they keep a list. But it's not really, as far as I've seen, it's not always been, from what I hear from other practitioners, it's not always that reliable. But they do, for wealthy families, they do keep track of this. But sometimes they don't catch it till way later. Like the Showcase Cinemas family, I'm forgetting the name. If anybody knows it, let me know. But that family got in trouble like 30 years after the fact for some gift tax things. And so did the Trump family as well. There's some gift tax finagling that wasn't quite done right. So.
But on a general basis, you don't have to go back and look at tooth fairy payments.
Yeah.
40 years ago.
Yeah, so this is the thing. At your death, when your heirs are looking at the estate tax, how are they to know that you made these gifts 40 years ago? There is a time limit. You don't have to go that far back, and I don't remember exactly how far back you have to go. But if you had gifted more than the annual exclusion in the year that, the estate tax exemption amount, which right now is $11.4 million in the federal level, if over your lifetime you gave away millions and millions of dollars, then this is going to be more important. If that's not an issue, it's really going to be hard to tell, oh, Dad gave $30,000 to Freddie in 1999. But technically, you might have to have a record of that. So it's a very tricky, I won't forget, it's a very tricky area. Generally, you'll see this come into play for gifts within 3 years, 5 years of death. I think you only have to go back on the federal level. It might be 5. Don't hold me to it. But I don't think it's a 40-year process unless it's large sums of money. But yeah, so one caveat to this, even though they do basically bring back in those gifts that you made, let's say you made a large gift of $500,000 2 years before you passed or a year before you passed, that does come back into your estate when they try to figure out whether you have to file an estate tax and when they figure out the amount. But the way that the calculation runs when you fill out the form, it still saves money on estate taxes. So it would save you money if you made the gift than if you wouldn't overall. And you had a question.
Yeah, so this all comes into play, for example, at Morehouse College commencement speaker, it's paying off all the student loans. Is it
He's going to have to report that.
$15,000 per student and
Yeah. He's going to have to, the Morehouse College gift, he's going to have to report all those gifts he made over $15,000 to the IRS. Yeah. Unless he's smart and he sets up some kind of foundation or 501c3 organization, tax-exempt organization, and puts those funds in there and has that, I bet that's what he does. And then he has that organization make the gifts, then he'll probably get a tax deduction instead of having to worry about the gift tax. So that's probably what he's going to do. That would be the smart way to do it, because then your gift isn't going as far either. That's an interesting question. Any other questions before I go on to the wonderful tax topic, which is so full of details? Are we good? So estate taxes in Massachusetts, if you have more than $1 million in your state when you pass, then you have to file an estate tax return. Even if you don't, if you have real estate in Massachusetts, there's an automatic estate tax lien placed on that property. So when it is sold later on in the future, whoever is selling it has to sign an affidavit, no estate tax was due, and then that's fine. Or if it's, I've had cases where we had literally $1,002,002 and we had a property worth $800,000, we went ahead and filed the estate tax, even though we were just over, to make it clear that there was no lien. So we had clear title to the property going forward, because that's really important to title companies.
So the house, when you have to compute your assets, if you say if it's over $1 million, we get into this deal here, that includes your house?
Yeah. Yeah, so for that, the $1 million exemption seems kind of low for the state, because a lot of people with their house in their retirement and a life insurance policy, like working parents, they'll get the highest life insurance policy through work that they can get. And then that easily puts them over the $1 million, and you don't usually think about those issues, But one thing, if you are married, you have an unlimited marital deduction, so you can leave all your property to your spouse without incurring an estate tax upon the first spouse's death. But when you do that, that leaves all that money to the surviving spouse, and then on their death, they have even more, and there'll still be an estate tax that's owed. And that's where we get into the trust, where you can put provisions in a revocable living trust for a couple that says that I'm going to leave monies to my spouse, but they can make an election and then do some tax planning for Massachusetts or federal if it's applicable by putting some of the funds into certain subtrusts of this trust. So you can say, let's say you have a couple and they have $3 million and they each have $1.5 million in their own names, but altogether they have $3 million. So you might have the first spouse say, when the first spouse passes, they might put $1 million in one subtrust and go ahead and tell Massachusetts, hey, I'm going to go ahead and pay the taxes on this $1 million, which I'm not going to owe because I'm under the $1,000,001, but I want it to be counted as mine for my $1 million exemption, and then the rest of the funds are held in another subtrust. And then when the second spouse dies, that $1 million in this subtrust is not part of that surviving spouse's estate, because we made that claim when the first spouse died. Unfortunately, the only way to make this claim is if you have a revocable living trust for this couple set up that has this subtrust in there, or you're really on top of it as soon as the first person dies. But it's best to have it in that revocable trust ahead of time with an election, because it might turn out that it's better tax-wise not to put it in the first spouse to die's estate and maybe make gifts to the kids instead, from the second spouse's during their life. So I like to make it a flexible arrangement in the trust. On the federal level, they have a box you can check to claim the first spouse's exemption, which is so nice, but that doesn't help us here in Massachusetts, which is a little frustrating. So Massachusetts and the federal government used to use the same tax form for estate taxes, but we decoupled in 1999, I believe it was. So when you fill out the Massachusetts estate tax return, you're using the federal estate tax return from long ago. It's kind of funny. So there's no box to check to claim that exemption, which is why we have this complicated arrangement that we put into trust for couples. So that's fun to think about. And what other tax? Oh, the other tax issue, we talked about capital gains. The estate tax on the federal level, Massachusetts is staying strong at $1 million. There's no talk about any change. There's been some proposals to make it $2 million, but they've never gone anywhere. I don't even think they've gotten to any committees from what I've heard. But on the federal level, as you've seen, it's just like a roller coaster. 2010 was the year to pass away because there was no estate tax, and then that went back up again. And now the one we have, 11.4 million is the exemption amount on the federal level per individual, and that will sunset in 2026 back to a lower amount, and then who knows what will happen between now and then and after that. So, yes.
On this estate tax, $1 million is exempted, but if you have $1 million and $5, do the taxes of $5 or $1 million and $5?
Yeah, so exempted isn't really the right term, I guess. It's not. The $1 million, it's a threshold amount in Massachusetts. So if you have more than $1 million, you do have to file an estate tax filing and pay an estate tax potentially. You could have enough deductions that you come out to less. But you're taxed all the way to that first penny. So if you have $1,000,001, you're going to be taxed. It's a graduated tax rate, so you're taxed, between this number and this number at this rate, this number and this number at this rate. So that's how that works. On the federal level, it doesn't work that way. You're taxed on the amount over the $11.4 million. So it's kind of crazy. Do we have any other questions on the wonderful world of taxes? The thing that gets people confused a lot is that annual exclusion, that $15,000 gift a year. Massachusetts runs the Mass Health program for Medicaid for long-term care, and they have this 5-year look back that's set under federal regulations, that if you make transfers within 5 years of needing Medicaid, then it's going to count as basically a disqualifying transfer, and you'll lose benefits for the amount of time that money would have paid for. So these $15,000 annual exclusion gifts are gifts. They don't care that it's not taxed on the income tax side. It doesn't matter to Medicaid. So that doesn't really help. If you're making small amounts of transfers of less than $1,000, it's not usually an issue. The main thing is Mass Health is a program for impoverished people for their long-term care needs, to help pay for their long-term care if they need, nursing home care. And they don't like when people take their money and move it around, and then, they're paying for their care when maybe if they would have had money, they could have paid for their own care, which is why we have a 5-year look back. So when you are looking at Mass Health and trying to figure out how that works, they have the 5-year look back. When you apply for benefits, they're going to ask for 3 years of bank records. And they're going to go through those bank records and look at what your transfers are. And they might have some questions, what was this for, what was that for? And they have the right to look up to 5 years of records if they request them. So, yeah.
This is probably the time to ask.
Yeah.
About the 5-year loan. I already have something 5 years.
Great.
4 years in. What happens when it moves to 7 or 10? Would that be grandfathered?
It has been in the past. It used to be a 3-year look back,
Yes,
and then it changed to 5, and it was grandfathered then. I would imagine it would be grandfathered again.
Okay.
The 7 years hasn't gone very far, so that's one hopeful anecdote there.
It's still 5.
It's still 5.
Right.
But the rumor of the 7 years has run rampant. And people have argued with me saying, no, it is 7 years. I'm like, no, it's not 7 years. So it could happen, but it has not happened. Right. One thing I've seen is you may have set up, some people will put their home into an irrevocable trust because of the Mass Health lien issue or the 5-year look back. But if that trust doesn't have the right terms, sometimes Medicaid, or even if it has the terms it should have, you can read them in the stat. Well, good luck reading them, but they're in the statute. Even if it has the terms and meets all the requirements, they might still look at it and say, this doesn't look right to us. We're going to say you're ineligible because that house shouldn't have been transferred. And then you file an appeal and make your argument. So that's my caveat on those irrevocable trusts. We have to draft them. If you put your home in one, it should be drafted very narrowly and not have any smidgen of any property going back, maybe income, but that's just one scary anecdote. But Mass Health, you're really looking at a point in time where you're needing a high level of care. And it's one of these things where you look at that issue and you try to figure out how you would face it, and it's really hard because you don't know if you're even hopefully you'll never need that level of care. But it is a big strain. It costs $15,000, sometimes $18,000 a month for certain facilities, and it's very hard. And it's very disheartening if you worked your whole life to pay off a house, which you plan on giving to the next generation, and then, here you are facing this. I mean, the only good thing is, if you have that house, at least you're able to take the equity out or sell it and pay privately or get in-home care, instead of having to ask your kids to help out, or instead of having to go to a nursing home because you have no other resources. So that's another caveat I give people as well.
Or you could have bought long-term care.
You could have bought long-term care insurance.
Which is an arm and a leg, but
yeah.
And you may never use it, hopefully, but it's like car insurance. You never have an accident, but you still have the benefit of the protection.
Exactly. Yeah, if you had purchased long-term care insurance and it met the requirements of a certain amount, I think it's $125 a day of coverage for 3 years, I believe. I think it's in the book.
Usually 3 years.
3 years. Then if you had a home in your name and then you needed to apply for Medicaid, they're not going to put that lien on that house because you took measures on your own to try to pay for your own care, because that long-term care insurance will pay for some of that care, and it helps. So.
But once the long-term care benefit is
exhausted
or used up, I guess if you had no alternative, you'd have to go to Medicaid at that point.
Yeah. Yep. But generally, you might apply, because it's not going to cover everything. So sometimes you still need to apply even with that long-term care insurance coverage, because it may not pay for that amount every month, And when you do end up needing long-term care Medicaid benefits, you're going to take your income and apply it towards that cost of care to offset what the state pays for your care. So that's one thing.
Now, if you have a couple that owns their assets jointly and one has to go in a nursing home, what happens to the assets?
That's a good question. So if you have a couple and one person needs to go to the nursing home and the other person's healthy, generally what I advise is you can make unlimited transfers to your spouse, and it's not a disqualifying transfer for Mass Health purposes. So you can only have together, including retirement and cash value of life insurance policies in your home, well, not including your home, all of those assets can't total more than $126,420, I think it was. It's in the book as well, all together, which isn't very much money. No. But at that point, once you've spent that down, then the ailing spouse will become eligible for Medicaid and Mass Health. But what you would do with the home, because if Medicaid is paying for care, Medicaid is going to place a lien. They have an automatic lien on that house. So basically, any federal or state agency kind of has automatic liens on everything, which sometimes necessitates probate. Yeah. But what you would do is you would transfer the home to the name of the healthy spouse, then apply for Medicaid, or do it after you've applied. They let you do that still. And then there's no lien that will accrue because the person who's receiving the care is not the owner of the house. So that helps too. But either way, if you don't, that's why you need a power of attorney too, so somebody can sign for that ailing spouse. But even if you can't do that for some reason or another, Medicaid will place a lien on the house, but it's going to be at their pay rate for the facility, which is less than you would have paid out of pocket.
So if you have spouses, I'm the power attorney for my husband, he's paying for me, is that the way it's supposed to work? Or?
Yeah, that's what most people do. Yeah. And then you might have a child or a good friend as your secondary agent. It's always good to have a backup agent, maybe more than one if you can, just in case somebody can't serve or moves away or passes away or something of that nature. Yeah, but Mass Health is really complicated. There are certain times when you can have an asset passed to a child if they provided care for 2 years. There's certain small exceptions which are somewhat covered in here. But some of these exceptions they've gotten really strict on, especially the one with the child providing care. They'll want to have proof that that child provided, basically 24-hour care. And sometimes if the child's been working, they'll say, no, that wasn't enough. It gets really tricky. Yeah, so going back to Mass Health, it's very tricky. As a single individual, you can only have $2,000 in assets, so you have to be really careful. You can spend money before you need to apply for Mass Health on yourself. They don't, if you're buying a Jaguar, they might have a problem with it. But if you need to buy new clothes, things like that, that's fine. But once you make transfers to other people, that's when there could be some consequences. And they might, if the person returns the property, then you might just spend down at that point. But it's always good to have cash. It's best if you're going to need long-term care in a facility that you're able to pay privately for a period of time, because the facilities only have so many Medicaid eligible beds, and you want to try to be able to go to the facility of your choice. And if you're able to pay privately for a period of time, you're more likely to get that, and then they'll just transfer you to a Medicaid bed at that point.
So if everything is joint and you realize somebody's going in a nursing home or something, the other spouse can put everything in their own name?
Mm-hmm.
Oh.
Yeah.
Okay.
Yeah, because they don't want to impoverish that healthy spouse, because then the state will end up paying, for two people basically, because you'd end up having to get other assistance. Yeah. Yeah.
Isn't there a limit to how much asset value
It's
can be
100.
transferred to the healthy spouse?
There's no limit. There's a limit on the total assets that a couple can have. I believe it's $126,420. It's in this book. I thought I folded it over. Here it is, page 15. $126,420. Yay, I remembered, and I didn't have my extra coffee. So this makes me happy. So a lot of this is covered in here, and they have really nice examples, these little blurbs, that really help illustrate this too.
Good.
Yeah. But yeah, it's a good question. Always remember, you can make unlimited transfers to your spouse, but again, in order to become eligible for Mass Health, your asset limit is $126,420. Does not include your home unless your equity in your home is more than, I think it's $878,000. It's a large amount of equity. Sometimes what people would do is, if they needed, ideally, you want to try to stay at home as long as possible. You might, if you don't have a lot of cash, get a home equity line of credit to pay for some at-home care so the spouse can stay home as long as possible. That reduces your equity somewhat as well.
Do they count your 401ks?
They do, and they don't care.
You can't really touch them.
That's the thing, is you can, and they don't care that you have these income tax consequences. That's too bad, so sad is kind of the answer. It's a little harsh, but the idea is that it's a impoverishment program, and there's a lot of people in the state that don't even have retirement.
So the Medicaid applicant can
Yes.
have that 126,000 something?
Oh, no, good question. The Medicaid applicant can have $2,000, and then the spouse, altogether, the Medicaid applicant, the spouse can have $126,420. So you transfer those funds over to the healthy spouse's name when you're getting ready and when you do the application or after. Yeah. Hi.
Can the healthy spouse divorce and run off with the assets?
That's the danger.
What happens?
Well, what happens? I guess it depends on what jurisdiction they go to. No, if they run off with the assets, at that point in time, you've already become eligible for Medicaid, the unhealthy spouse. So there's that. But yeah, that's a risk, and maybe if that's a risk that you have with your spouse, I don't know the answer.
Can they go after the divorcee?
Oh, you mean if there's more than 126,000?
Yeah, let's say it's a big case.
Yeah, so let's say you have like $3 million and you transfer everything to your spouse, and then they divorce you or they take off. So in that case, you would file the application. You would explain to Mass Health what's going on, and they're not going to leave the ill spouse just flailing in the wind on the street somewhere. They're going to provide some funds, and there'll be some care provided. But that is a strategy that some people have started implementing, not quite running away and divorcing, but the divorce option has sometimes been used to allocate assets between spouses to reduce assets. But
can the Mass Health approach the divorcee?
No, then they're not even, an ex-spouse isn't part of it. They're not a married couple anymore. Yeah, but that is a strategy that some people have used. It's not a very popular, easy one for attorneys to offer to clients. It's It's a very strange thing, but I mean, I have had clients where they've been estranged for years and they don't live together, but they're still married because they still have a bond. But I had a couple who hadn't lived together for years, and so the argument would be, my assets are mine and his are his, and we file taxes separately, we do everything separately, and you just explain that and provide some documentation, and they will potentially try to go after that spouse. I mean, that's the risk you run. In other states, like Pennsylvania, there's even been cases where they've gone after kids. That has not happened here. But there are some strategies, some last-minute planning strategies, including divorce, but that actually takes longer than a last minute because you have to get a judgment nisi and you have a waiting period for divorce. It can take you about a year. But some last-minute planning strategies include setting up some type of annuity or putting monies into a pooled disability trust. Those options may not be available for very long because they've talked about making that not an option for last-minute planning for Medicaid eligibility. They are covered somewhat in the book, but at this point they've already drafted rules to change that to not be an option, so not really going to discuss it too much, although it's still something you can use today. So what that means is if, let's say you're let's say you have $200,000 and your spouse is ill and you're over that $126,420, you could take the excess and put it into a pooled trust for the benefit of that ill spouse. That pooled trust would be run by a nonprofit. There's a few of them that are operating right now. And that would have funds that could be used for that ill spouse to cover anything Medicaid doesn't cover, like haircuts or new clothes. And then upon their death, the nonprofit gets paid their fee, and Medicaid gets paid back what they've paid, and then whatever's left could go to whoever you've named. The same thing with these annuities, although they have fees as well. There'd be a Medicaid payback in there. They're not the best options, but they are there, if you needed them. So, yeah, it's not much fun. Any other questions on those? Any of these other issues? You do have to be wary when people try to sell you annuities as you get older because they don't always make as much actuarial sense. I had somebody come in the other day. He was 65 and he was convinced to take his retirement and roll it into an annuity. And they told him it's going to double in 10 years. And it sounded great because why wouldn't you want to do that? So he rolled it over into the annuity, and they forgot to mention at 70 and a half, he had to start taking required minimum distributions. This was all of his retirement. He didn't have another retirement account to take those required minimum distributions from. He was forced to take them out of this new annuity. So he's not going to reach the doubling of his investment because he has to take the money out. So be really wary. He thought he read all the paperwork, and it's just a little disheartening. So
He had to start withdrawing after...
At 70 and a half, you're required to take minimum distributions. Yeah.
Because that's the
yeah.
federal RMD.
Exactly. And if you don't take out those required minimum distributions, they're going to tax you 50% of that required amount. Right. So you really should take it out. And he didn't have other retirement accounts from which he could say, I'll just take them out of the other account. This is all he had. Yeah. So just be careful. Try to read over those terms carefully and just be wary. Also watch out for financial scams. I'm sure they told you about them here. And spoofing and people calling saying that they're your grandson in Mexico for spring break and he needs money right away. And those calls, the fake calls from the IRS, oh my God, they're crazy. And now they have fake calls from Social Security that they're making. One of my friends got one. So never give your Social Security number out with the phone. They're awfully convincing sometimes. So.
They say Social Security will never phone you.
They will never what? Phone you? Oh, interesting. That's good.
The IRS.
The IRS and Social Security will not call you, so do not believe them when they do because it's not them. They will mail you. Yeah. That's funny. They still use mail. Does anybody have any other? I don't think there is. Oh, I didn't talk about life estate deeds. Those are a nice vehicle to avoid probate for real estate without having to have a trust. You could draft a new deed of your home, retaining the right to live there for the rest of your life, and then leaving it to what they call remainder persons. So it would be a new deed, and you would say, I give my home to Freddie and Joanne, retaining the right to live here for the rest of my life, is the general language. And then upon your death, it conveys to those remainder people, but during your life, you have the right to live there. And capital gains, because they don't receive the property till your death, you don't have that capital gains problem we talked about. They step up. And if you needed Medicaid within the 5 years, you might still have to convey it back. But if you didn't need Medicaid until after 5 years of that conveyance, you've only retained a small percentage of the ownership of that home. So that's my last thing. A life estate deed.
Life estate deed.
Yes. I don't know if it's in here. Oh, there's no index. Oh, I love indexes or indices. But this book is great. Hopefully it's...
And who pays the taxes and everything else?
Oh, page 50. Yeah, that's the question you have to work out with your... Sometimes kids are living in the home and they've drafted a deed like this. It kind of depends, but generally it's going to be the life estate holder is going to pay the insurance on the property and the real estate taxes and the carrying costs of the property because they're living there. So page 50 talks about that, and it talks about homestead declarations as well. Yeah. Great. Wow, it's 2:15. I was worried I wouldn't have enough information. So. Thanks. So don't forget to check your beneficiary designations and look over any estate planning documents you have and make sure that the terms are still what you want. Yeah, as well. Nothing else? We're all good? Thanks, guys.
Thank you.
Yeah, you're welcome. Extra books. Oh, thank you. You guys are so nice. Thank you. We can't give pass Uncle Sam. No. My friend will have a book.